All rise.
Thank you. Please be seated. The next case to come before the court this morning is State of Ohio versus Quintina and Edwards. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, you can see there, it says 5, but if you'd like to reserve less than 5, of course, we're okay with that as well. Please don't use the names of any minors or victims, as we are recording this oral argument and it will be placed on YouTube, the course YouTube channel. We have read the briefs and we're ready to proceed when you are.
May it please the court, Kevin DiMartino on behalf of the State of Ohio, the appellant in this matter. I don't need to reserve any time. We are asking that this court reverse the trial court's decision sealing Ms. Edwards' conviction for child endangering in violation of 2919-22B, which was a felony of the 4th degree. The record, of course, has been sealed, but the sentencing journal entry reflects from 1997 that the plea of guilty was to 2919-22B3. The interpretation of a sealing statute and the eligibility for an applicant to qualify for sealing is reviewed by this court de novo. Sealing is completely governed by statute, which is 2953-32. A1 defines an eligible offender as anyone convicted of a crime other than the crimes that are set forth in 2953-36, which was the applicable statute at the time of Ms. Edwards' application for sealing. That section, 2953-36, excludes 2 particular categories of crimes that apply here. The first is in A4, which is an offense of violence. The second is in A7, which is a victim under 16. An offense of violence is defined in 290101. It's particularly A9 of that section includes child endangering under 2919-22, B1, B2, and B3. As I indicated, Ms. Edwards pled to 2919-22B3, which pursuant to 290101 is an offense of violence. There's also 3 appellate courts that have acknowledged that a felony conviction for child endangering is an offense that's not eligible for sealing, and that was NRA DMC out of the 10th district, State versus Paz in the 11th district, and then DDG out of the 8th district, which are cited in the briefs. The second applicable statute would be 2953-36A7, a child who's under the age of 16 at the time of the offense. The child endangering indictment reflects that it was a child under 18. That was in 1997. The offense was on December 17th, 1997. The transcript from the sealing statute reflects that the victim was now going on 30 in 2021. So for someone to be going on 30 in 2021, they would have had to have been born in either 1991 or 1992, which would make a child in 1997 5 or 6 years old under what's in the record. So we have the indictment, which has the date of the offense, the year of 1997, and then we have the transcript, which reflects that the victim was now going on 30. That would clearly place the child under 16. The indictment does reflect under 18, but based on the year of the sealing and the fact that the victim was going on 30, that would show that the victim was under 16. Because of those 2 sections of 2953-36, Ms. Edwards was not an eligible offender, and the trial court lacked the jurisdiction to seal her conviction. So based on that, we would ask that this court reverse the trial court's decision sealing the appellee's conviction for child endangering in violation of 2919-22B3 of felony of the 4th degree.
And counsel, there is some argument in the appellee's brief regarding the court's inherent authority to seal a conviction. Was any of that discussed at the trial, below at the trial court?
No, it was not.
Thank you, counsel.
Thank you, Your Honor.
it please the court, Attorney John Stiles for appellee Quintina Edwards. We have laid forth in our brief two arguments for the court today. First, that Ms. Edwards was an eligible offender under 295332, and I guess as a subsection to that, that there was no exception that applied under 295336. The second argument is, as you just recently addressed, was that this court does have inherent authority to seal this record, even outside of the Ohio Revised Code. So pursuant to 295331, there's essentially two ways that somebody is defined as an eligible offender. First, under subsection A, either all the felonies are of the 4th or 5th degree with no offenses of violence, or that there's not more than 2 felony convictions, 4 misdemeanor convictions, or not more than 2 and 2 of each. Ms. Edwards, as her criminal record at the time of this offense showed, she did not have anything greater than this 4th degree felony that she had been convicted of in 1997. 2919-22, specifically the child endangering statute, is defined, as counsel for appellant stated, as an offense of violence only when it is under B1, B2, B3, or B4. As the sentencing entry in this record actually shows, she pled to a 4th degree felony, and that felony was, that statute code was essentially undefined. So she pled to a 4th degree felony, and I guess I'll quote specifically, it says, the court finds that the defendant entered a plea of guilty to endangering children, ORC 2919-22, a felony of the 4th degree. That was quoted directly in the sentencing entry. So as this was undefined, I guess the question becomes, how can we find a way that this falls under B1, B2, B3, or B4? So if we look at 2919-22 as a whole, really what I did was I looked for how could this have become a 4th degree felony and still been a conviction under endangering children. So the two ways that 2919-22 defines a 4th degree felony of endangering children is that the offender had previously been convicted of an offense under 2919-22, or if they had violated subsection C of 2919-22. Now, assuming that this was under subsection C, that would not make this an offense of violence and unexpungible or unsealable based on that. And further, Ms. Edwards had never been convicted of an offense under 2919-22. So as it stands, there is no way that this could have been under B1, B2, B3, or B4 that she would have been convicted. So the second part of this inquiry basically goes down to what was before the court to show the age of the alleged victim in this, or the victim in this case. Essentially what we have in front of the court was that the court did an inquiry with Ms. Edwards about a child that was involved in the case. What I will, I guess, submit to the court is that there was not evidence really before the court or before this court that shows that that age, that the named victim was the victim that was discussed at this sealing record. I don't think that in the record there was enough information there to ascertain that the child that was named in the indictment was the child that was discussed at the sealing record. But for that reason, I don't think we have enough information here that would tell us what the age of the victim was in this case, nor essentially an identity of the victim that was discussed at the sealing record. All of those things considered, if this court does find that that Ms. Edwards was not an eligible offender, that essentially leads us to appellee's second argument, which is that this court does have inherent authority. Now, as was asked earlier, was this addressed at the trial court? What I will submit to the court is that an inquiry was done. The trial court did ask several questions of Ms. Edwards at that time about, I guess, her performance and what she has done in her life since the time of this conviction. At that time, Ms. Edwards provided a series of statements to the court explaining that she had a good relationship with her children, that she was working, that she was pursuing new career opportunities that required a sealing of this record. And the court made a finding at that time that she had been sufficiently rehabilitated under the law, which warranted sealing of her record. I think the way that the court came to that was based on this balancing act that was laid out in Pepper Pike, an Ohio Supreme Court case, both in Pepper Pike and in Boykin, which Boykin was decided by this court or reviewed by this court, stated that a trial court has the inherent authority to expunge records apart from the statutes when justified by unusual and exceptional circumstances. I think those exceptional circumstances are warranted here where there are some confusions and some concerns beyond the statutory requirements here.
But counsel, both of those cases were unique circumstances, weren't they? I mean, with Pepper Pike, that was before the new statutes that talked about expunging somebody's record. The record include like an indictment and a no, I mean not an indictment, no bill, but I mean a indictment or complaint and then it's dismissed with prejudice. So, you know, the interest there is somebody that's not even been convicted of a crime and there was no statutes really to deal with that.
I would agree with that, Your Honor. What I would say though is that cases, I guess, that fell beyond Pepper Pike were decided after those statutes had been revised. Boykin came after those revisions and Raber also came after those revisions. Raber, I believe, 2015 case, if I remember correctly, it was a 2014 case, excuse me, where this case was a case in which there was a conviction. Now, the statute in that case actually fell directly under the exception. So, I would say that Raber, while the court did follow through with an analysis under the Pepper Pike and that followed after Pepper Pike and Boykin, what I would say is that the conviction in Raber fell squarely underneath the statute that excluded him from having his sealed. Here we do not have that instance. Here we have an instance where Ms. Edwards was convicted under something that doesn't fall as to an exception or an offense of violence. So I think that they're distinguishable in that regard, and then this court went on to that balancing analysis that's in Pepper Pike. So I would argue that at this point we have an opportunity for the court to use its inherent authority to justify the sealing in this record. The trial court went through that analysis, found that Ms. Edwards was rehabilitated under the law, and for that reason was justified in sealing her record. For those reasons, I would ask that this court affirm the trial court's decision to seal Ms. Edwards' record in this case.
Thank you, counsel.
Thank you.
Thank you both for your presentation today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court's website.